Hi, everybody. It's Tom Klein. This is the webinar with "You don't have to agree, but you do have to comply." That's an old phrase that one of my old employees, Hank, used to tell me when he really didn't want to do something, and I understand it completely. So before we get into compliance specifically, let's take a 40,000-foot view and let's talk about risk mitigation and corporate governance, because compliance is one of the three key components to make sure that you're protecting your dealership. Now, I call these the three legs of the stool because any one of them, if you pull the leg out, the stool falls over. So the first is dispute resolution, and dispute resolution is everything like handling your online reputation to handling your lawsuits, handling things with the attorneys general, handling things with regulators, anything that has to do with a consumer or an employee, importantly. And that's dispute resolution. That's leg one. Leg two is compliance, which is what we're going to talk about today. And leg number three is risk transference. And risk transference is anything that you can do to defer risk to a third party, or to put a policy and procedure in place to make sure that you're stopping problems or intercepting problems before they happen. Now, risk at the dealership is always the two biggest areas are number one, consumers, and number two, employees. And it's important that you know that when you're thinking about compliance. You manage what you monitor. If you're not looking at it, it's not getting managed. So let's take a look at compliance from that perspective. And I'm going to show you what I think you should be monitoring. The first thing about compliance is that Chapter 8 of the United States Sentencing Code, which means that if you do something wrong, when the judge goes to sentence you, there are two factors that mitigate punishment. And one of them is the existence of an effective compliance program. So when you're thinking about compliance, and I know this is the worst case scenario, this is really something to consider because this is no joke. There are 7 pillars of compliance. Excuse me. And if you notice here, there's actually more than 7 pillars on the building, but close enough, right? So the first is implementing policies, procedures, and standards of conduct. The second is designating a compliance officer. Then training and education, effective communication, monitoring and auditing, disciplinary guidelines, and detecting offenses and corrective action. So if you have an effective compliance program, these are the standards that you have to follow. And these are pretty common within any compliance program. Now, the first thing and most important when you're considering a compliance program at the dealership is for you to sign a consumer protection compliance charter. And this is a document that commits you in writing to having a chief compliance officer, which assists the board of directors in oversight for the dealership's compliance program. Super important. If a regulator walks in, you can say, here is our consumer protection compliance charter. And by the way, you are mandated by the Consumer Financial Protection Bureau, or the CFPB, to have a compliance program. This is the beginning of the program. And remember that in the dealership, if it's not in writing, it really never existed. So make sure you have a consumer protection compliance charter. And if you want a copy of that, please reach out to me. I'll be happy to send it to you at no charge. As a part of any compliance program at a dealership, you have to focus on IRS Form 8300 compliance, which is the cash reporting requirement. And where I see dealerships making big mistakes is not receipting it properly. So how to receipt? You should have a separate method of receipting for traveler's checks, cashier's checks, money orders, or multiple payments. So for example, personal checks are not cash according to the IRS, but cashier's checks, $10,000 and even, $10,000 even and below are considered cash, as are traveler's checks. Now, not many people use traveler's checks anymore, but people do use cashier's checks. So if somebody actually brings in cash or hard currency plus a traveler's check or a cashier's check, that's considered a reportable situation. And the penalties for lack of IRS 8300 compliance are severe. It's up to 5 years in jail and $5.5 million for willful non-compliance and $500,000 per occurrence. So this is nothing to mess around with. I mentioned a few minutes ago, you're required to have a CMS or compliance management system as mandated by the Consumer Financial Protection Bureau. And listen, this can be something as simple as a 3-ring binder. As long as you are putting things in about what you're doing for compliance in this 3-ring binder. For example, if you handle a customer problem and that gets resolved, you should write a quick report of discussion, what happened, and put it in the binder. That's perfectly fine as far as the CFPB. You certainly can have a SaaS solution in the cloud, and there are a lot of good programs, but at a minimum, you have to have that binder. I've been asked to make sure to discuss conditional delivery agreements. So if you are delivering RVs of any kind before the customer's credit has been approved, that's a conditional delivery. Now, each and every state has different laws, and obviously I can't get into them here, but if you're delivering units before credit is approved, I suggest that you have an addendum to the buyer's order in the retail installment sales contract. Some people call that who's this? A MacArthur agreement, because MacArthur said, I shall return. And a conditional delivery agreement should say, I will return this vehicle or this trailer back to the dealership if my financing doesn't get approved. If you are recontracting the customer after you've given them a conditional delivery, they didn't get approved the way you put them out, then I suggest a rescission and substitution agreement, which is a super simple form that just says that your old APR, your old and the old terms of the loan, the amount financed, the monthly payment, and the new one. And it says, I understand that I don't have to buy the RV, but if I do, these are my payments. So this is really handy when plaintiff lawyers want to tug on your coat strings and tell you that the customer didn't know that they could get out of it. You pull this rescission and substitution agreement out and say, hey, they signed something showing the old terms, the new terms, and it was very plain. So here is an example of the description of the previous contract, date of contract, contract rate APR, and the payment amount. The description of the replacement contract, something really simple. I'm glad to provide this if you want to reach out, or your lawyer, of course, can draw something up for you. Part of compliance that's really important is that you have twice monthly training with an employee sign-off and acknowledgement. So each month you want to train your employees on 2 different topics of compliance, and then have the employees sign off an acknowledgement. You file that in their employee file, and in the case that a regulator walks in and says that you're willfully non-compliant, you simply pull out some of your personnel files and say, hey, I understand we made a mistake and I apologize for that mistake, but you can't really say that I'm non-compliant when we trained on this on June the 15th and this one on June the 30th and this one in July and this one in August, and you go through it. It's very It's very moving, and it's very important when a regulator sees that, they understand that you are trying to comply. Compliance helps prevent problems. This smug-looking guy is looks like a plaintiff lawyer who is ready to sue you if you don't have a compliance program, and that's why he looks so happy, and that's why he's got this cigar. The best way to prevent lawsuits and class action exposure is through your employee guidebook. Making sure you have all of your policies and procedures in your employee guidebook. As a part of that, to prevent problems with your employees, do you have a legal rights agreement? Do the employees have a specific way that you want them to proceed if they have a problem? That's what a legal rights agreement is. Can you or do you have a class action waiver on customer documents? Class action waivers are enforceable in some instances, and so you should talk to your attorney about those, whether you can put those on your consumer-facing documents. And finally, are you complying with the Fair Credit Reporting Act? So the Fair Credit Reporting Act is a complicated act, but in essence, what I'm talking about is when you fill out a retail installment sales contract, the dealership's name is in the upper right corner of that retail installment sales contract. Some plaintiff lawyers will assert that you are a creditor as the dealer. And if you're not sending a letter of denial to the customer when you pull their credit, so they come in, they want to buy an RV, and you can't get them approved, the plaintiff lawyer says that you as the dealership actually have made a credit decision, and therefore you owe the customer a Fair Credit Reporting Act denial letter. Now, failure to do this includes treble damages and punitive damages. Treble damages means that you triple the damages. So this is not something to mess around with, because you can imagine if you took all your customers who came in to try to buy an RV, and all those customers, you pulled their credit, and then you start multiplying these numbers out, your class action exposure is tremendous. Part of compliance is knowing what's actually happening in your F&I department. Have you ever had anybody audit your deals to go through your policies, your practices, and to see what happened, to see what's happening? I read a review yesterday of a dealership that a customer came in, the customer said that the manager came in after he did not want to buy a extended warranty. The manager then came in and did a TO and tried to bump him a 0.5 percentage point on the APR because he wouldn't buy a warranty. That's so illegal. You're really going to get burned if that's something you're doing. So are you auditing your deals, and what's happening in your F&I department? We're going to talk about the red flag rule very briefly. You have to have a written plan. This is to make sure that somebody's not stealing identities. That's what the red flag rule is. So you have to have a written plan. There should be a program detection checklist, and we're going to touch on some of these right now. What are you doing about alerts and notifications when your managers get them? Do they bring them to you? What happens if there's suspicious documents or personal IDs, and when are you supposed to notify law enforcement? So one of the ways you can tell if somebody has stolen somebody else's identity is by having out-of-wallet questions. Out-of-wallet questions is when someone's sitting in front of you and you ask them questions and say, what are the 3 previous cities you've lived in? And if they can't roll those off their tongue, you know it's not them. Or who are your 2 previous employers? What major credit cards do you currently have? Or say, in other words, verbally say your social security number. These are a few of the ways that you can tell whether the person in front of you has stolen an identity. Now, a lot of software programs will prompt these out-of-wallet questions, but you have to follow them. The red flag discrepancy checklist, 1 or more pieces of identification. So how do you tell whether the person sitting in front of you is actually the person who's saying they are? So you have to have one or more, so two. So driver's license, passport, voter registration card, birth certificate, debit card, credit card, you see a concealed weapons permit, social security card. So any of these are okay, but not having at least two of them is a problem. Also, verify the address to a third party. Power bill, gas bill, cell phone bill, any of these things are okay when you're trying to verify that this person is who they say they are. Be careful when there are credit freezes. So when somebody's frozen their credit, that's a red flag, pardon the pun. It's something really you should check into and before you sell them an RV. Also, are there other alerts or notifications or suspicious statements or activities? A huge number of very recent inquiries on their credit report is a problem, or obviously them acting nervous, or documents or ID seems to be fake or altered. You'd be surprised how many times I've talked to managers who say, yeah, well, the ID really didn't look right, but I sold it to them anyway. You know, stop that activity. That's really a problem. Not finding these violations, the regulators will fine you $3,500 per violation. So again, a very important program. Part of your compliance should be making sure that you have buyer's guides on vehicles, especially when they're used. Make sure that the proper boxes are checked, whether there's a warranty available. Have you made sure that these are being filled out properly in F&I? And if you're conducting business in another language other than English, did you know that you have to have an FTC buyer's guide filled out? Part of compliance is advertising and making sure that your advertising is accurate. For example, does your website talk about a doc fee? Doc fee is old school language, and most states don't allow you to have a doc fee. Most states allow you to have a processing fee. So what does your website say about that? Does all your ads say plus taxes, tags, and processing fee? If it doesn't have those, then it's assumed by regulators like the Federal Trade Commission, it's assumed that those are part of the price that you're asking on your website. So make sure you have that disclaimer language in there. If you're posting payments on the side of the units, make sure you have the other items covered. So posting a payment is a trigger term, which means you then need to tell them how much down payment, what the length of the term is, and the APR. Are you disclosing damage to new vehicles? If they get hit either on the lot or in transit, every state has a different law. So do you have a policy and a procedure to do that? The next thing is, do you have asterisks on website prices? A lot of people have disclaimers, most dealers have disclaimers, but if there's no asterisks next to the sales price, then again, it's assumed that all those fees are included as a part of that price. And then finally on this slide, see dealer for details has been determined by the Federal Trade Commission as being vague, and they don't want terms that are vague. So those terms are not in favor. There's a big disconnect between sales and advertising. Does your sales department know what your advertising says? Because when a customer comes in on an ad, if the sales department doesn't know about that ad, then the customer may leave pissed. And that's where they go complain to the Consumer Financial Protection Bureau or the FTC. So make sure that you're training the sales department on what the advertising says. Otherwise, you're going to have a problem. It's going to create a problem. So compliance is part of risk mitigation, which is part of a continuous improvement activity. You have to create and maintain a compliance management system. Then by using best practices, you will unearth problems. and you'll find those problems in your operation because you're doing compliance. That gives you the opportunity to fix them and make sure that both the consumers and the employees are happy or satisfied, because that's the primary area where dealers get caught up and have big problems. If you have any questions for me, please reach out. I appreciate your watching today. I'm Tom Klein. Thanks for seeing things from a better vantage point.